dear colleagues, I think that I will be very boring because when we are speaking about interesting issues, this always causes a number of problems. And so that's why it's much better to skip everything which would be of current actualities. And in fact, I would like to show you how the International Criminal Court is working. And I try to manage also the techniques, in fact, and I skip also the long historical narrative that I wrote in the book, how things were going from Péter von Hagenbach till the adoption of the Rome Statute. In fact, so there's a technical problem. First challenge. You know the institutions. In fact, there's the Assembly of States Parties, which has several duties. On the one hand, this is a kind of a lawmaking body for us. The resolutions of the Assembly of State Parties are important in order to amend the Rome Statute. The Assembly of State Parties has the duty to elect the judges of the ICC, and of course the budget depends on the Assembly of State Parties. We have also the Office of the Prosecutor, currently led by Mr. Karim Khan, having a British nationality. And in fact, when I just mentioned something about the election of the judges, so the so-called equitable geographical representation, also the gender parity, and also the professional parity should be observed when judges are elected with two-thirds majority. It's not at all easy, and in fact, I was elected in the 22nd tour. Maybe it was at that time that I reached the threshold of two-thirds of the members of the ASP. The ASP is practically the two-thirds of the General Assembly of the United Nations, and the sessions are also either in The Hague or in the UN building in New York. When the judges are elected, we are put in different divisions. There are the so-called pre-trial division with the pre-trial chambers, there are the trial chambers and the appeals chamber. In fact, most of the judges can work in different chambers. For instance, normally I am in the pre-trial chamber number 1, but I am involved also in the trial of Dominic Ongwen, and currently Jakatom and Gaisona. And when there is a problem with someone in the appeals chamber, but there is a judge who is free, he is elected as an ad hoc judge for the appeals chamber. So that's why practically all the judges are working in all the divisions. We have several institutions dealing with witnesses. Some of them are below the registry, and there is a special institution called the Trust Fund for Victims. Its main job is to assist and to repair the witnesses, the victims. As such, there are the so-called own sources and the other sources. The own sources means the fines that we imposed during the trial practically did not happen too much, so this is an empty envelope. And the other sources, this is what is important, these are the contributions, voluntary contributions of states and of private individuals. And it is from that the trust fund is working with a considerable amount of autonomy. And so there, the competence of the judiciary is rather, let's say, limited over them. What is the subject matter jurisdiction of the ICC? In fact, our competence involves the genocide, with the same text as the 1948 Convention, crimes against humanity, war crimes, grouped in two groupings. On the one hand, concerning the international armed conflicts and violations of the non-international armed conflicts. And also there is the aggression competence. In Rome, the states were not ready to define the aggression, and they said that maybe later it can be adopted. This happened at the Kampala conference, and this had to be ratified by 30 countries, 30 state parties in order to enter into force. This happened, in fact, in 2017, and it was after that that the Assembly of State Parties passed a decision when to apply, and so, in fact, we say that it will be in July, 1st of July 2018. So we shall see, we can never go beyond some important dates. And it means also some of the problems for us. What are our main principles? On the one hand, we should put an end to impunity. That is to say that soldiers, officers, generals, or even public officials should be aware that they can be kept by international and national mechanisms, and they should be put on trial. But this concerns the more serious crimes. You may ask, what are the more serious crimes? In fact, this depends on the large scale of the victims, also on the geographic pattern of the crimes, also their impact on the regional stability, and so on, and also, of course, also the cruelty of the committed crimes. All this should be done according to the principle of the complementarity. Complementarity means that the job of the state is to adjudge at home the perpetrators, and if the perpetrator is put into trial at home, on national level, and if he gets an adequate punishment concerning the committed crime, at that time the ICC had no reason to step in, to intervene. We are very satisfied that the given guy got what he deserved. But if the state is unwilling or unable to intervene, it is at that time that, on the basis of complementarity, we should enjoy competence over these persons. Jurisdiction rational and rational personae. This is rather complicated, as you can see in this slide, because on the one hand, I made a distinction between the ordinary crimes, so genocide, crimes against humanity, and war crimes, and aggression. And it's very important to see what I try to color with, that normally either, so the ICC has a jurisdiction if the crime is committed on the territory of a state party or by nationals of a state party. So the condition is enough. However, according to the Kampala Amendment and aggression, this is not an either or, but an and, which is required, more or less. That is not only the state party capacity, which is important, but the fact that the given country accepted also the Kampala Amendment, and it did not profit from the so-called opting out clause. Then there is a state which, for different reasons, is not a state party to the Rome Statute. Nevertheless, it can accept the jurisdiction of the court, and this occurred, for instance, in the case of Ukraine. And it happened, I assume, in 2013, maybe, that Ukraine declared for some events occurring on her territory that she accepts the jurisdiction of the ICC. Since then, the territorial acceptance was enlarged to the whole territory of Ukraine. And so this is a bit similar like the unilateral engagement of whatever state. And this can also be okay for the jurisdiction. But it's another issue whether this can work also in case of an aggression. And here the academic world is divided, and let's say the majority view is that here this unilateral engagement does not work. There a formal membership, formal state partnership to the Rome Statute is required, and a formal acceptance of the Kampala Amendment. And of course, the Security Council can also differ situations to the ICC, also concerning the state parties as well as non-state parties. So logically or legally, the hypotheses are clear, but in fact, you know pretty well the story, the history of the United Nations of the Security Council. So it's better not to expect too much from the efficacy of the Security Council, especially in highly politicized cases when permanent member states are concerned. Rational temporis jurisdiction. Once again, there are some dates. So we cannot go back before 1st of July 2002, let's say the entry into force of the Rome Statute. But if a state joins later, the date of his accession prevails. There are some small amendments adopted since 1998, and for these crimes, the precise date depends once again on the fact whether the state is bound by them, ratified these amendments or not. And in case of the aggression, as I said, so this is after July 17, 2018, but if the given country ratifies the Kampala Amendment later, the entry into force of its ratification will prevail concerning the date. And once again, you know, there are 123 state parties to the Rome Statute. Therefrom, there is a good, I think a good 40 which are bound also by the Kampala Amendment. Some states are not bound by that. By the way, also our country, Hungary, did not ratify this amendment for an unknown reason. What is the applicable law for us? It's a bit similar like Article 38 of the Statute of the International Court of Justice, but you remember from your studies that as to the ICG, the sources are on equal footing. However, in the Rome Statute, there is a kind of a hierarchy. So first the statute and elements of crimes and rule of procedural offences, and it's only after them that other international treaties can be applied, or the so-called customary law. And here, by the way, you can also see that in the first place, elements of crimes and rules of procedural evidences, these are norms adopted by the Assembly of State Parties. This is not a treaty law, but in fact this is quasi-hard law for us, and precedes the ordinary international treaties. And after that, the so-called general principles are coming, and we may also use our previous jurisprudence, and all this should be done according to the human rights. it gives an impetus for us to profit from the jurisprudence of the different human rights tribunals, whether this is the European Court of Human Rights or whether these are the Inter-American Court of Human Rights or eventually the African Court. Who are those who may trigger the procedure? On the one hand, these are the state parties concerning the situation in another state party, or if a non-state party recognizes the jurisdiction of the ICC, he may also apply the attention of the prosecutor but to situation occurring on its own territory, and the prosecutor can act concerning whatever state party or proprio motu, so ex officio also, and in fact the Security Council can also act, but in fact, and Nora Beres knows better than me, up till now, in fact, there was only two situations which were deferred to us by the Security Council. So the so-called Sudanese situation, or Darfur situation, and the Libyan situation. And these cannot be considered as the most powerful achievements of our jurisprudence. I mentioned that there are situations which are referred to the prosecutor of the ICC, and it's very important, let's say, philosophically. So this is not a concrete case which should be pointed out by someone, by a state, but a situation composed of several cases. And this is the prosecutor which will choose that case, those cases, or that case, which is important for them. But this choice will be done, on one hand, in total independence, and according to the principle of impartiality and objectivity. There are several stages during the examination of the situations. There is, of course, an analysis and the test of the subject matter jurisdiction, geographical jurisdiction, personal jurisdiction, and the rational temporis jurisdiction, and then comes the test of the admissibility to check the issue of the complementarity as such, and to check also the gravity. And there is also another test, this is the so-called interest of justice. And this is also a challenge because, as you know well, justice in Hungarian can be translated in several versions, and it is absolutely behind all the problems, whether this is the so-called functioning of the judiciary which should be understood, or whether this is the abstract justice for victims which should prevail. And in fact, here, let's say, our jurisprudence is not so well established. Up till now, there was one case, the Afghanistan case, which was stopped by a pre-trial chamber on the basis of the interest of justice, in the sense that because of lack of cooperation on behalf of the authorities on the place, my colleagues did not see any real chance to do that. The appeal chamber, however, overruled this decision by pointing out that the interest of justice can be evoked only by the prosecutor, and the court and the chambers can check whether the prosecutor rightly invoked that or not. But if the prosecutor did not refer to the interest of justice clause, proprio motu, the chamber cannot do that. And so that's why the appeals chamber said that the Afghanistan situation should go ahead. It happened still under the previous prosecutor, Mrs. Fatou Bensouda, and the current prosecutor inherited these cases after the collapse of the Afghani provisory government, and so currently he tried also to evaluate the opportunity which could be in fact the cases which can be prioritized therefrom. And maybe you followed that. It was followed with a certain criticism in the press. So in fact, what I was speaking about, this was the so-called preliminary examination, and after that this is the investigation. And once again, the admissibility test should be done, because it can be that in the meantime, at home, the national procedures have already been launched, accomplished, or arriving to a good stage, and there is no use to double the procedure also before us. In fact, it would be contrary to the clear text of the court. And once again, the gravity should be told, and the interest of justice. This was the previous prosecutor, Mrs. Bensouda, who once made an explanation concerning the interest of justice problem, telling that if the perpetrator is terminally ill and he is really at the end of his life, maybe this would not be proper to engage a very costful legal procedure if, according to all the probabilities, he will not be in life when the judgment would be prepared. There are different evidentiary thresholds before us, and I begin them with the lowest one. So concerning the step from the preliminary investigation to the preliminary examination to the investigation, in fact, this is the reasonable basis to proceed, and this is quasi the same for the issuing of an arrest warrant. But when there are already a good number of evidences and the prosecutor submits its charges, the DCC, the document containing the charges, and the pre-trial chamber is at that time in a situation like a juge d'instruction in France, and has to confirm the charges. At that time, this is the so-called substantial grounds to believe that the given person has committed these crimes. And in order to convict someone, this is of course the traditional rule of known in all human rights instrument. So the judges should reach their decisions beyond any reasonable doubt in order to condemn the perpetrator, the individual. In fact, I have already mentioned which are the most important aspects of the different chambers. So the pre-trial chamber has a kind of a juge d'instruction role over the actions of the prosecutor, and there is also a certain review if the OTP does not want to investigate. If the case, if the situation was sent by a state or by the Security Council, and nevertheless the prosecutor, I do not see any reason to investigate, this can be appealed strangely before a PTC, and the PTC, the pre-trial chamber, may ask the prosecutor to reconsider its position, but the prosecutor may arrive to the same conclusions that there is no need to investigate. This happened on a very lengthy way, the so-called Mani Marmara situation before my PTC, by the way. Summons to appeal or arrest warrants are issued also by the pre-trial chambers, and as I mentioned, the confirmation of charges, which is very important because if in the later stage it's not really clear what are the charges, this can have an impact on the legality of the whole procedure. And so this happened in a famous case, Mr. Bemba, who was condemned on first instance for 20 years, and he was acquitted nevertheless by the appeals chamber, stating that in fact those elements were playing an important part during the condemnation, which did not belong to the so-called confirmed charges, as the pre-trial chamber decided that. As again, this was a decision which evoked a kind of legal criticism, pro and contra. The trial chambers, of course, are dealing mostly with examining the individual liability of the perpetrator, and if he is liable, the sanctions are defined, which can be in extreme, in case of extreme situation, incarceration of perpetuity, so lifelong imprisonment, but normally this is 30 years, or in fact shorter terms. We condemned Mr. Dominic Convent for 25 years of imprisonment. First instance, currently this is before the appeals chamber. And if the perpetrator is already condemned, there will be kind of a reparation procedure for the victims, and this is also done by a pre-trial chamber, as we did that concerning the victims of Mr. Lubanga or Mr. Katanga. These are cases of eastern part of the Democratic Republic of Congo. If a person is acquitted, he can also ask for reparation, but only in cases of manifest miscarriage of justice. There were several attempts for that, up till now they failed to do that. Here, if the states would like to be more generous, they should modify the wrong statute. Currently, we are strictly linked to the fact that manifest miscarriage of justice should be done in order to compensate someone. Appeals chamber, of course, is dealing with appeals, in merito appeals, and also a huge number of interlocutory appeals. There's a kind of a symbiosis concerning the common law and the continental law. We inherit both from both of them. From the common law, this is the so-called no case to answer that I can show you as an example. This is such an institution that our jurisprudence accepted, which is known in the common law systems, that in the so-called prosecutor's case, the defense can provoke the end of the procedure if, according to the conviction of the judges, the given evidences will not be enough in order to convict the given person. So, in fact, with the no case to answer, the defense may provoke the stop of the proceedings without opening the so-called defense case. And in fact, this was done in the Kenyan cases and in the situation concerning Mr. Laurent Gbagbo, the former head of state of Côte d'Ivoire. From the continental law, what I would like to mention as an example, this is the role of the presiding judge, which is much more accentuated than the so-called tennis arbiter role of an Anglo-Saxon judge. So, to give an example, the judge may also reformulate the question asked by the defense or by the prosecutor, or can of course also pass a decision on objection. Can also say, okay, Mr. Prosecutor, please try to find such a version of your question which would satisfy these desiderata. And of course, there are a good number of jurisprudential interactions from the jurisprudence of the International Court of Justice or the Rwandan or the ex-Yugoslav tribunals, the Court of Strasbourg, the Inter-American Court, or the Special Tribunal for Sierra Leone, and so on. But of course, also there are references to Nuremberg and to all the well-known cases. So to say something in general, we are arriving to the conclusion, by the way. So International Criminal Court, this is international and criminal and court. And so that's why here we may meet all the traditional problems of the international law as such, whether these are the so-called relative weakness of the international law as such, the problem of the United Nations Security Council, or we met also problems of those civilians who, despite of their civilian status, put up arms and engages into military activity in case of a naval blockade, for instance. We have also problems with the states' cooperation, and we met also soft law and different conflicts of norms, and so on and so on. And of course, we have the traditional questions of penal law or criminal law, so the evaluation of evidences, the real or potential exculpatory evidences, examination of aggravating and mitigating evidences, nebis in idem, and so on. What is in fact our job? This is to contribute to a better world by investigating and sanctioning, if possible, but also by deterring the potential perpetrators from committing crimes, and we try to push all the state parties to cooperate, and also to push those states, or to kindly invite those states which are not state parties to cooperate with us. Maybe this can be felt a bit as a naive idea, but from this point of view, it's very interesting that our relationship with the United States of America is changing, and there was the so-called first period of Mr. George W. Bush when he was against the ICC, but during his second presidency he helped our institutions. The connection, the contacts and the relationship were very, very good under Mr. Obama. At that time, for instance, American diplomacy played an important role in order to transmit certain perpetrators to The Hague. After this was Mr. Trump's period with quasi lack of cooperation and huge animosity, and under Mr. Biden, once again, there is a very, let's say, warm, or rather correct relationship. Anyway, there are once again different help, intellectually, politically, on behalf of the states, and all those sanctions which were promulgated under Mr. Trump were revoked. This concerned, for instance, Mrs. Basuda and one of her lawyers, and in fact, even if the official US position did not change in the sense that US citizens cannot be adjudged by the International Criminal Court, nevertheless, the US said that the International Criminal Court should play a very important role in the international criminal judicial mechanisms, and also in the current challenges as such. And we contribute to a better world also by the cooperation, and also by the cooperation in the jurisprudential development of international humanitarian law and international criminal law. Nevertheless, nothing is perfect, as the Fox said it in Petit Prince of Saint-Exupéry. So there are non-state parties. As I mentioned, there are 123 state parties. It means that 70 70 states are not state parties from the UN family, but the greatest problem is that from among the permanent members of the Security Council, the US, Russia, China are not state parties. From other important countries like India, Pakistan, Indonesia, Malaysia, Israel, they are not state parties. Nevertheless, it depends once again on case-by-case assessment whether despite of the non-membership there is or there isn't any kind of cooperation. And as I already mentioned, the position of the Security Council of the United Nations is critical for the proper functioning of the world. This concerns also the ICC. So if the Security Council does not sanction those who do not obey to the arrest warrants issued by the International Criminal Court, at that time it's not so easy to convince the so-called naughty states to arrest them. It is not impossible, and there are other international organizations who may impose sanctions like the European Union. And so from this point of view, some problems of the improper functioning of the United Nations Security Council are, if not counterbalanced, but a bit improved by the European Union and other organizations, or by other wealthy states. We have no own enforcement mechanism, and we have always under budgetary challenges. States like the zero growth policy, states would like to see first more results and then to pass a decision on a higher budget, but it's also a kind of human right, so the translation costs are enormous for us. And when I am in the Yakatom and Gaisuna case currently is concerned the Central African Republic, there the translation is not only between English and French, but also the Sango, which is a traditional language of the Central African Republic. The same was in Uganda, and there the traditional local language was the Acholi, but there, if the case requires that, there are translations from Arabic. So, and you know well, all those who are organizing conferences know well what the translation cost means for the organizers. And so this concerns also a problem of regional solidarity. There was so many African states who said that there is a kind of bias in the US. Why these are only African people who are before the court? And it was very easy for them to say that only our leaders are targeted, and they forgot that all these situations were referred to the ICC by their own leaders. So these cases, these situations arrived to us in so-called self-referrals. And nothing is perfect. The Rome Statute is either. So there are also some, let's say, logical problems, incoherences, such parts which are not easy to understand. But in such a situation, to engage in a complete revision, it's impossible, and it wouldn't be proper at all. I like very much international law, as you know that. Nevertheless, I cannot deny that this is not the strongest norm of the humanity, and so this concerns, in fact, the ICC as well. And lengthy activity of the international organizations felt everywhere concerns us also, so it's not so easy to engage deep reforms, and all the deep reforms have also deep budgetary impacts, and sometimes also labor law challenges before different international labor law judiciary institution. So once again, we are not perfect, but we try to contribute to a better world. Let's hope that we will succeed. Thank you very much.